I'm not coming in as a freaking defendant. You guys got to stop saying you're the defendant all the time, because a defendant can never. There is nothing in the rules where a defendant wins money. A defendant always loses money, or he breaks even, but he never wins anything. Why do I always want to be the loser? I don't ever want to go in a game of chess or Monopoly and say the best I could do is lose. Why do I want to play? What's in it for me? I don't see a reason for me to be here. You know what? I'm going to make a reason for me to be here. I'm going to be the winner. Somehow I'm going to win. I'm not going to play. So you're interfering with my right to a jury trial. Right. Okay. Somebody's claiming I owe them a debt. Okay. Who's claiming the debt? An attorney can't make a claim. He can't claim anything. He has no idea what went on between me and the other party. He wasn't there. He doesn't know what we agreed to and how we were going to make the terms and the conditions. He has no clue. He's coming in as a third. He's coming in so far in the end of this matter. It's scary. He has no clue what's going on. And I'm not going to sit here and explain, turn state's witness on myself and explain what actually happened between me and the supposed person who's claiming I owe them a debt. I'm not going to sit here and explain. I'm not going to turn state's witness on myself. Let the plaintiff bring the information forward themselves. Let the plaintiff swear to it.
Do I tell the judge that the attorney can't talk and can't swear or bring in a claim?
You told the judge in writing this, right? Because you're not opening your mouth to the judge, right? You already established that you were never going to open your mouth to the judge, right?
Right, but how could I tell him that he's proceeding against me if I'm not in court? You said that he's having a hearing and I'm supposed to go into court, and I'm saying you're still interfering with my right to a jury trial. Why? Because you're having this hearing. This is all in writing, not.
Like I said, you put it all in writing. If you go to court and if you want to read word for word what you said, Judge, what don't you understand in this thing? I said, I will appear when I see a jury present. I do not see a jury present. I will not be appearing today. You're interfering with my right to a jury trial. That's what it says right here on line number 2. Are you still interfering with my right to a jury trial? You asked the judge, yes or no. I said, well, then there is no reason for me to be here today. What is the purpose of this matter, the hearing today? Because I don't know how you are going to move against me when you know you're in violation of the law. You're breaking the law, Judge. You're interfering with my rights. You can't do that. You can't outstep outside of your scope of authority. You took an oath of office to uphold and obey a certain sort of rules. Because I said you already established the fact that she is a judge and that she took an oath of office under Title 28, if you're going under a federal court judge, or under, like, say, I'm trying to remember, is it Title 4 or Title 5, or Article 6, Clause 3, where every state employee and every judge has to take an oath of office to be bound by the Constitution. So you're telling the judge, are you breaking your oath? Are you breaking your promise? Are you breaking your word that you contracted with the people to abide by the Constitution? Are you telling me right now, and you telling everybody in this courtroom right now, that you're not bound by the Constitution? And that you feel that you could breach your contract with the people, and that I'm just supposed to accept that? Is that what you wish to have happen today? But you put everything in freaking writing. There's no way in the world the judge is going to allow you. Like I said, when I do that to them, they all recuse themselves in the pre-hearing trial because they said, "Holy cow, I am not going to get into the courtroom with this crazy guy Karl. He's going to tear me up. He's tearing me up in my own chambers. I'm certainly not going to let him put me on a public display and tear me a new hole. I'm going to recuse myself and say, oh, I know the person you're suing, Karl. I went to grade school with them. You know what? My sister had a barbecue with them last Thursday. I'm going to have to recuse myself. Every judge I go in front of, they all recuse themselves at the preliminary hearing in their chambers. They all recuse themselves because you put them on a spot there in their chambers. You set up a preliminary hearing date, a precipice day. That's how you nail all these judges. You don't wait until open court. That's crazy. That's suicide. You put them all in their place in writing. You ask for a preliminary hearing trial. You establish the rules. This is how I'm going to appear. This is how I want them to appear. That's where I want the jury to sit. Judge, that's where I want you to sit. This is what I want you to do. That's what I want them to do. It's your case. You're packing the suitcase. I want my socks over here. I want my tissues over here. I want my Kleenex over here. I want my curlers, my iron, and my hairdryer over here. I'm packing my case. This is my case. My case, my suitcase, my case and my suit is going to be put on in front of the jury. I'm going to put on my suit in front of the jury. And they're going to determine the merits of my suit. They're going to say, hey, that's nice. I like the way you fucking did that collar. Yeah, it's pretty cool, ain't it? Yeah. They're going to see my accoutrements that I attached to my case. My witnesses, here's my exhibits, here's my testimony. Hey, I got a pretty cool suit in this case, don't I? Yeah, that's a pretty cool suit. It's American Idol. Yeah, we're your judges. Yeah, thumbs up. You win, buddy. It's all a game. It's all a show. You just got to know how to play it. Once you know how to play it, it's fun. Until then,
Getting back to this letter number 1, I'm saying you're interfering with my rights to a jury trial by jury.
Okay, I like that.
Okay.
Uh-huh.
And that's only one line, and that's it? That's all I say?
Well, that's a good thing to say you're interfering with it. Then what I would do is I'd put the terms and conditions, and if you insist on interfering with my rights, and I appear on the 30th day, like you wished me to or you ordered me to, and I don't see a jury there, I'm going to be extremely upset. And I'm going to charge you $10,000 for wasting my valuable time because you know the rules. Under Article 6, Clause 3, you took an oath to bound by the Constitution. I'm using my 9th Amendment and 7th. I'm just going to use amendments right now, so I don't confuse you.
All right, I know, I understand.
I'm going to say the 7th and 9th Amendments. I have the right to a court of record. That's the only court, that is the only form of court that's secured and protected by the Constitution of the United States. There is no other court established in the Constitution for the people. Everything else is due to an act of Congress. The federal district courts, circuit courts, Supreme Courts, are all, except for the Supreme Court, are all acts of Congress. The only other court that's mentioned is the Supreme Court of the United States, but that's the Supreme Court of the government of the United States, not the Supreme Court of the people. It's the Supreme Court of the government to put the checks and balances between the executive branch and the legislative branch. That's all the Supreme Court of the United States was for the checks and balances of the governments and the states. If the state had a problem with the feds had a problem with the state, they could go to their Supreme Court and slug it out. That's what the Supreme Court was built for. It wasn't built for us. Our court is a court of record. That's the 12 people in the jury. 7th Amendment clearly stipulates once it's decided before a jury, it can't be retried. It can't be heard in any court in the United States, including the Supreme Court. It's simple.
Now, Karl, real quick, you write that letter to the judge, or do you put it in as a filing in the case?
Oh, you write it straight to the judge. You don't do none of this nonsense in the newspaper. If I was you, I'd send it to the judge. I'd send it to the Judicial Review Board of the state. I'd send it to the circuit court judge as well. That you got an out-of-hand, crazy district court judge down here that is totally a Looney Tune. But you don't say that. But at least they'll get the grasp of what you're trying to go with. So don't go too patriotic. Don't make it 800 pages long. Make it 1 page long, maybe 3 sentences, and you're done.
So you say if you insist on having this hearing in 30 days and there's no jury present, I'm going to be extremely upset?
Yeah, you basically say it as nicely as you can. It's like, I'm going to realize that you still don't believe I have a right to, under the Constitution, that this matters more than $20, and you still believe that you have the right to interfere with that. I'm going to be highly upset, and I think your boss is going to be upset at the circuit court, and I'm already notifying him as well, and I'm putting you on notice. I'm letting your superiors know that they're going to be held liable. And you could do that, say, writ of mandamus thing that I'm demanding. I'm going to demand of them that you obey the law. And if you don't obey the law, they're going to take over. So how are we going to do this, ma'am? Or how are we going to do this, Judge, sir? How do you want to play this game? You want me to put you on notice with your boss and say that you're not holding up your oath of office? Where do you want me to go with this, sir?
So will I expect an answer?
I hope they don't give me an answer. What do I want an answer for?
If they don't answer, you say they're acquiescing.
I'm suing them.
To the fact that you're going to get a jury trial.
And I'm going to prove to the jury. I gave them time to answer. They refused to answer, jury. You know the rules. He knows the rules. The maximum law, tacit acquiescence, is acceptance of the rules. There you go. They accepted
that's your second letter? You write your second letter?
You
acquiesced?
No, you put that in your first letter. Say if you refuse to respond, if you fail to answer, you know the maximum law.
Okay.
If you refuse to answer in 72 hours or 14 days or 6 months, that, I'm going to use this as a form of tacit acquiescence to prove that my claim is just and true and fair. And I'm going to present this to the jury as evidence of why I'm suing you. You could sue somebody for interfering with your rights. Nobody's immune to doing it. Nobody can interfere with your rights. You claim you got a right, nobody can deny you right. Your rights can't be surrendered. They can't be revoked. They can't be taken away. There's no such thing. If they could take away your right to do something, it's a civil privilege. It's not a right.
any way you could give us the procedure after that to establish the case in the federal court?
Like I said,
your own sausage.
You just basically told the other side that you said in the first letter, you said, if we can't settle this matter on a private side, I am going to move it into a common law court of record in a federal district court, because obviously I'm not going to get a fair hearing in a state court because you're a state judge. You get paid by the state. Obviously, your buddy's going to back you up. So you know what I'm going to have to do? I'm going to have to take you into the federal court. How do you want to deal with this, lady? And then you got to make sure, like the federal rules say, you know, you got to abide by certain federal rules. You know, you got to say, look, you know, I can't. You know, she's interfering in my rights. It's a federal question. You just say it's a federal question, and you let the federal district court judge decide whether or not she had the right to interfere with your rights to a jury trial. Right. That's what I say to people about declaratory judgments. You could write to the federal district court judge and give him a declaratory judgment. Ask him, can you give me your opinion, federal district court judge? I got a state lady judge who's giving me a hard time interfering with my right to a jury trial. Can you give me my standing if I brought it before you? How would you rule on this? And the judge will say, well, okay, a state judge lady is giving you a hard time. Yes. Okay, this is her standing. This is your standing. You're using Article 6, Clause 3, and she's ignoring you, right? Good. He'll give you the opinion. And then he'll send the opinion to the judge lady. And he'll say, now, judge lady, you still want this lady to drag you into federal court because I already ruled in her favor. Because now when she comes here, she's going to win in a half of a heartbeat because everybody here at the federal district court already is aware of what's going on. So, are you sure you don't want to settle this on a private side? That's a declaratory judgment.